As was kindly pointed out, I held my last talk about the harmonization on special excise taxes 10 years ago, 1995, in fact, longer, 1995. Now I'm going to be telling you about legislation in Brussels. There's to be an amendment of the Directive on excise taxes. That's why the title might be somewhat misleading, because we're not talking about present-day amendments, but present-day negotiations for later amendments, and if everything goes well, we'll have adopted the directive by the end of the year. For those of you who are not very familiar with excise tax law, I'm going to give you an introduction to the directive, which regulates the procedures, the transit procedures, the arisal of taxes, and tax debt law. This is the directive which is more important than those that deal with amounts. I was fortunate enough to be involved in the negotiations, and now we're looking at a comprehensive amendment of the law. Years ago, the Commission had already tried to modify parts of this directive. In January 2005, in fact, the negotiations were abandoned without any results. But the Commission is making a new proposal, and we're seeing another attempt at resolving these issues. This has to be done in a somewhat hurried fashion, because in contrast to 2005, the European Parliament and the Council of Ministers have told us that we have to introduce a new transit procedure with the aim of transforming a paper trail with accompanying documents to an electronic trail. Excise taxes are doing what customs has already done. After all, there is already an electronic customs transit procedure, and so the excise tax people have decided they want the same thing. And so the Council and the European Parliament in June of 2003 took the decision that this procedure had to be introduced, which explains the enormous time pressure, because according to the Committee on Excise Tax, this has to be introduced by the 1st of April 2009. The Commission and the Member States have offered 35 million euros to develop the procedure, and if it's underway, 100,000 economic operators will be linked through a network for this procedure. I'm going to explain the procedure very rapidly. The accompanying documents will be replaced by electronic declarations, and the sender will be sending a draft of the administrative document prior to shipment, and the formula will then be checked to make sure it's complete, and a reference code is issued which will allow people to follow up the shipment. The consigner will also have a copy of the electronic document, and this will be transferred to the authorities of the recipient member state as well as the consignee. And once a consignee receives it, he has to confirm reception, and the receiving land's custom will also be included in the electronic declaration procedure. After 15 days, this has to be reported to the relevant customs authorities. This is then sent off to the country of departure, and their the customs authorities of the land of departure will then inform the consignor that the procedure has been finished, and the procedure will be over the consignor will have been released of all obligations. So much for the theory. You can see how much effort's been made to develop this procedure, and much will be done afterwards as well. The biggest problem we've got right now is that we don't have any legal basis for this procedure. Up until now, the system directive, the consignor is only obliged to use paper documents, but if industry is supposed to use IT next year, they need software, they need hardware, they need the specifications of the system, which are still being debated in the committee, or still have to be. So it's very surprising that the Commission, which is aware of the transition from paper to electronic documents, made the proposal in February of this year. Anyone who knows how negotiations are taken in Brussels realizes that it's absolutely unrealistic. Something else has to be considered. The directive has to be implemented in national law. The parliaments need at least 6 months, even if the directive has been adopted, to adopt secondary legislation. We have to change our excise tax laws, and other member states are also going to have to amend their laws. Another aggravating aspect is that the directive not only deals with excise tax, but all sorts of other aspects. So in fact, this is going to be a completely new directive with many details related to transit or custom procedures or exemptions, and all this must be negotiated. The working group in Council has dealt with this on 3 occasions and still have not achieved consensus. In July, the General Customs Directors are going to have to decide whether the time plan can be respected, and I should imagine that, notwithstanding what Parliaments and Council have required, we're going to have to postpone adoption, and in fact the procedure will only be up and running in 2010. What is entirely unresolved is whether, for the transitional period, we're going to be able to use the administrative document alongside IT solutions. But because what if the operators have not implemented hardware or software, and transport starts with alcoholic or tobacco, and people don't have the necessary IT solutions available. Because we don't have enough time to go into all details, I'd like to give you an idea of a few other amendments that the directive includes. On the one hand, we're talking about transaction and taxed goods, and Council in 1992 pointed to the potential, but also massively overestimated the potential. This only accounts for 3%. Taxed goods only account for 3% when compared with untaxed goods. Why is this such a small amount? Why is this so moderate an amount? Well, it's because of the charging procedures. If you're exporting to another member state, the charging procedures are very complicated and inconvenient. This is not going to change. This is, of course, an obstacle that trade does not take account of this in an adequate scope. Now, transit trade is another aspect, and clearly it only works through private people, after all. The consignor sends a private person a shipment, and the private person is not supposed to process any of the documents, and the private recipient is not supposed to pay taxes. This is supposed to be carried out by the consignor, the shipper. They receive a document. They're supposed to go to the country of destination, and every procedure is given a reference number, and this number must be indicated on the trading document of the bill of lading. That is not going to facilitate procedures much. We can see that the Commission really wants to exercise greater control, and I would like to predict that this procedure is going to not lead to transit blossoming. In fact, operators are going to be very, very hesitant. A private person can hire a carrier to transport goods from another member state. In fact, if we look at private people who wish to buy alcohol or cigarettes in another member state and take it back, in fact, it's explicit that only those people who bring back the goods themselves are able to benefit from tax benefits. They have to be physically present, and if they ask someone else to do so, they are not subject to tax exemption, and then they become tax debtor in the member state of their residence. What people have forgotten is, for instance, the sending of presents. What's not been resolved are, for instance, goods which are transported because of marriage or the change of domicile. You know that from the Regulation 118. In Procedure 92, this whole area was unfortunately forgotten, and the proposal which is now being put forward would solve this problem. However, it was impossible to achieve consensus among the member states, so the Commission has decided to amend the original proposal, and what's changed is presence between private individuals. This is still being discussed, both as regards tobacco and alcoholic beverage, and we're going to see whether the member states agree with this. There's a slight liberalization of trade, but it's not a major turnaround. Other potential, it was interesting for me to hear Professor Witter's presentation of the modernized customs code, particularly as regards the extinction of customs debt. This harbors a number of problems, because if the proposal is adopted, this will be problematic. In the justification, I'm going to read you a sentence. So as to avoid double procedure, in other words, suspension and customs procedures, one has decided that the provisions on tax exemption will, with regard to goods that are being transported, shall not be subject to application. This is extraordinary. If goods are being transported or stored, we're talking about transit, we're talking about active and passive added value. We're not dealing with a procedure of tax suspension, but all of this depends on customs. The tax regulations are no longer applicable, and according to Article 21 of the tobacco law, we've seen the consequences of this for tobacco in both importing and exporting. It seems that the statement that the system allows for deviation, one could imagine that excise taxes on importing customs duties would no longer be applicable. In justifiable cases, we can just revert to tax law. However, if this procedure takes place outside the directive, if the directive is no longer applicable, if the taxes are not to be levied, I think this will lead to problems which the Commission has not really given sufficient thought to, what this regulation will apply. This has been my experience in negotiations, that customs experts and turnover tax experts, so in fact working in parallel, they negotiate these different taxes in a parallel fashion without the necessary consultation between these tax experts. For instance, a taxing of wrong quantities or disappearance or the loss leads to exemption. This lies in good excise tax tradition. Now the Commission copied Article 206 of the Custom Code. This is how it's been adopted. In fact, the arisal of taxes is supposed not to have existed if there is loss or disappearance or destruction of a good. My understanding from yesterday is that this aspect of Custom Codes will not be maintained. It's supposed to go through the extinction once the customs debt has been extinct. Will obviously not be applied. Then the Commission decided to announce that the whole thing will be dealt with by customs. I can't really understand this because the Commission understood that the new modern customs code was about to be published. Second procedure should be introduced because it makes us prick up our ears as regards this guideline, and that's the competence for levying of by member states in cases of irregularity. If you transport a good from A to B and it's stolen on the path, which member state receives the tax? This is of enormous interest to the member states because you know that excise taxes are going to flow 100% of taxes will go to the member state. In fact, if the money went to Brussels customs, it doesn't really matter who levies the taxes, but in the case of excise tax, it plays an enormous role. In the event of irregularities, if the good does not come by the recipient, then the member state of the country from which the good is exported is competent for levying excise taxes. This is, of course, of a definite advantage for big member states who have a larger chance of getting excise taxes if something goes wrong, and perhaps the former members of Yugoslavia, then they will one day become member states of the European Union, and suddenly we'll realize that Greece will be responsible for levying taxes. If when going through the Balkans, goods go missing, and one doesn't know in which country they've gone missing, it will be up to Greece to ask for the taxes. Malta and Cyprus aren't very enthused about this. We understand why. Although it may simplify things, it's also going to lead to changes in tax revenue. According to the present system, according to the directive, this is a fossil from customs law. It's practically a copy of the transit tax regulation. So this proposal may be quite explosive. What should be welcomed is a simplification that was intended. However, this will lead to modifications in tax revenues. One modification which might be welcomed is that we've seen the introduction of a new figure, a new type of person, the authorized consignor. Now, one can process and clear goods through customs before sending them to the consignee. Now, after all, only the people who dispose of a tax storage can send on goods without taxes, and who has that sort of thing? And now, in fact, such an authorized consignor will be able to send goods from one place to the other with the procedure of suspension of taxes. This amendment should be welcomed. It's going to mean a facilitation and relief for the economic operators. I'd like to say something about tax stamps. The Commission said that if a member state taxes, for instance, tobacco, that member state who's issued a tax stamp is obliged to reimburse the amount which has been charged for this stamp. This is a reaction of the Commission to two judgments of the European Court of Justice. The ECJ had recently been looking at the issue of the theft of stamps, either the stamps themselves or the cigarettes on which they'd been placed. No member state is obliged to provide someone with exemption for such taxes in such an event. And so as to mitigate the consequences of this judgment, the Commission decided that if another member state levies taxes, the tax will be reimbursed elsewhere. You can imagine that Germany wasn't very happy with this solution, and they've adopted a new solution in this proposal, which provides that in the event of irregularities, member states with the competence for levying is that member state which has initially levied the stamp tax. This is going to be the advantage of those member states who offer these, and we'll be looking forward to seeing how the member states react to this. There are all sorts of details that haven't really been discussed, and the whole thing is going to be, in fact, rendered even more complicated by the electronic proceedings which the European Parliament is trying to impose. And it seems that the directive will not be adopted in the ambitious scope and we can imagine that we're going to see a decoupling of the transit proceedings, because we can't achieve consensus. We should look specifically at the electronic transit procedures, so perhaps one could achieve this under the French presidency, so that perhaps it might be adopted next year and implemented. Thank you very much for your attention.